Hello, everyone, and welcome to the Employment Law Counselor Podcast. I'm your host, Jeff Stewart, and each and every episode we tackle the laws and regulations that make up the world of labor and employment law. Today, we'll be covering a little-known part of the Americans with Disabilities Act, the regarded as disabled provision. While our podcast is not legal advice, it is a practical discussion between two attorneys that deal with the maze and minefield of labor and employment laws on a daily basis. If you like what you hear, please give us a 5-star review and subscribe so you never miss an episode. As always, I'm joined by one of my colleagues here at White & Williams to discuss our topic of the day. Today, I'm joined by John Baker, who practices out of our Lehigh Valley office. How are you doing today, John?
I'm fine. Nice to be with you again.
I appreciate your time. So, I'm glad to have you here with me for this discussion on the regarded as disabled provision of the ADA. So, let's dive in, shall we?
Sure.
All right. Well, first off, we have the Americans with Disabilities Act, which has been around since 1991 and prohibits discrimination against qualified individuals with a disability. Most people know that. Then there was the Americans with Disabilities Act Amendments Act, which was passed in 2008 and expanded the definition of disability even further to have even more people covered and to be deemed disabled under the law. But what most people don't know is that there's this little known provision that gives certain people protections under the ADA, even if they don't have a disability. And that is the regarded as disabled provision. Have you dealt with this, John?
As a matter of fact, I have. I've had several cases involving the regarded as provision. The regarded as provision is unique in that it offers protection to an employee who does not technically fit into the definition of the disabled employee.
And John, before we started recording, you were telling me that you actually had to explain this provision to an appellate court judge who doesn't really deal with this area very often, but was completely unaware that this provision even existed.
Yeah, I found that to be very interesting, very telling about how little regarded the provision is. That I was having a conversation with an appellate court judge in a state court who had asked me about my recent cases. And I said, yeah, I just got summary judgment on this regarded as provision under the ADA. And the judge looked very quizzical and wondered what the heck I was talking about. And later on, the judge asked me to send a copy of the summary judgment opinion so the judge knew exactly what this regarded as provision meant.
Nice. Well, just to give our listeners a little peek behind the curtain here, we kind of bounce ideas for episodes off of each other. And John and I were talking about how to relate this regarded as disabled provision. And we both are fans of the show Seinfeld. And in fact, we're watching a Seinfeld episode the other night where George Costanza, one of the great television characters of all time, had an episode where he was regarded as disabled. Now, just a little background. There's a famous episode where George decided to start using a walking stick, a cane, and took it with him to a job interview. He was then hired, given an office with a private, handicapped accessible bathroom. And only after he was hired did he realize that the person who hired him must have thought he was disabled. Now, from there, George plays it up and actually pretends to be disabled. But let's go back to the job interview. Suppose George had not been offered this job. John, do you think he would have had a claim under the regarded as disabled provision?
Well, as I explained to employers, they always have a claim. The key is whether the claim is going to survive. Either way, whether they have a claim or not, the employer is going to have to pay legal fees to defend it. But I believe that if the employer uses the fact that George had a cane, perceives that George is therefore disabled, and subsequently does not hire George on that basis, then yeah, George would have a claim.
Yeah, and it's important to note that he's not disabled. He's not claiming to be disabled. It is the employer's perception that is the controlling factor in a regarded as disabled claim. Now, let's say George gets hired and his new boss, who's not the one who hired him, but his new boss didn't like that he had a cane and subjected him to higher standards than other employees. Do you think that would also fall under the regarded as disabled provision?
Well, anytime a decision is made that is adverse to the employee, that is based upon a discriminatory factor, yes, there is a claim. And in this case, if the employer used the fact that George had a cane in any way, then yeah, he could proceed with a claim.
Yeah, because holding someone to that higher standard is a form of disparate treatment that is treating one person differently than another, which is a form of discrimination. Now, in this episode, George was found eventually to be faking his disability. Now, John, I'm going to ask you, are there any protections there for somebody who fakes a disability? Can they be regarded as disabled?
I would tend to think not. I don't know exactly what the law says about that, but I do know that a jury would not look very kindly on someone that was faking it. If an employee comes in, claims to be discriminated against on the basis of a faked injury, that would stretch the limits of acceptance.
I tend to agree because this is regarded as disabled, not regarded as faker. So I don't think that there are any protections there. So let's move outside of the Seinfeld world and let's look at a couple of examples of places where we see regarded as disabled cases. There was one case recently where an employee was struggling and their boss made the comment that you must be dyslexic or something to be messing up this badly, and then fired the employee. And the employee brought a claim saying that their boss clearly regarded them as disabled because he made this comment that you must be dyslexic or something.
What do you do in a case, Jeff, like this? But when it's, at least the way I understand it, it was clear that the boss was just joking.
Well, again, a joke is hard to defend yourself because when you are in front of a jury, you're looking to try to explain the intent. Well, the employee hears one thing and the boss may have meant something different, but it's really up to the jury then to determine the intent of those words and whether or not the boss was in fact joking or seriously believed or perceived that this person was disabled or suffering from a disability of some kind. So in this case, I will tell you that this case was not dismissed immediately. It survived a motion to dismiss, which meant the employer had to defend it. Now, what this also tells me is that this is a company that needs some supervisor training because supervisors, when they make statements like that, are just opening the door for an employee to bring a claim. And you never want your supervisors doing that.
Yeah, I find that the supervisor training is to bring supervisors, managers, owners up to speed on landmines. And landmines are certain words that, while not illegal in and of themselves, but they certainly raise the awareness of the employee who is the recipient of those words that there could be some discrimination going on. What that does is that the employee thereafter is uber aware of any adverse consequence they may suffer in the workplace.
Agreed. All right, so let's look at another example. An employee starts losing their hair and then decides to just shave their head bald. But then a rumor starts around the office that the employee actually has cancer. And even though the employee doesn't have cancer and is not disabled, they're passed over for a promotion. Do you think there's a regarded as claim there?
Well, at the outset, it looks like there may be one. Of course, the employer would have the opportunity to explain why this individual did not receive the promotion using legitimate business reasons for the decision.
Absolutely. But I think what's important to note here is that rumors can be the source of a regarded as disabled claim. It doesn't need to be any outright statements that are made or a supervisor doing something, but just having the rumor out there can lead to a potential claim that, once again, the employer is left defending.
I agree with that. I also, Jeff, have another example I can think of. Let's suppose you have an employee who had a heart attack. The employee recovers, is released to work without any restrictions. The employer ignores the restrictions part, the fact that there were no restrictions. The employer takes away from that employee certain duties, thinking that the employee can no longer perform them because, in this case, because of exertion or because of stamina, something of that nature. In that case, that could also be a regarded as issue because the employer ignored the no restrictions and on the employer's own decided that they were going to take extra caution. This employee would have a claim for the ADA violation of the regarded as provision.
And that's true even if the employer, and many times they are think they are acting in the employee's best interest. I've heard employers say, well, I didn't want him to have another heart attack, so I took away some responsibilities. But the problem is you are not able to substitute your opinions for a doctor's opinion. And if the doctor has specifically said this person is released with no restrictions, you can't put them under restrictions. Otherwise, you are regarding them as disabled.
Yeah, the employer's in a catch-22. They have to assess the risk between an ADA violation, although a very obscure provision, and a workers' comp claim. It's not an easy balancing act. That's where, consulting with counsel is a good idea.
Absolutely. Absolutely. So, interestingly, John, you wrote an article recently for our blog, which can be found at theemploymentcounselor.com, on the regarded as disabled provision of the ADA. Did you not?
Yeah, it was not too long ago, and everyone is aware of it, I believe. It had to do with Will Smith's smack of Chris Rock at the Oscars. I had a different take on that slap. And my take, unfortunately, as an employment lawyer, we think of things that happen in our own special way. The slap was over Will Smith's wife, Jada Pinkett Smith, who has apparently alopecia. And I started to wonder, is that a disability or is it a regarded as disability? If this were an employment situation involving Jada Pinkett Smith, and the employer decided not to hire Jada Pinkett Smith or took some adverse consequence if she were an employee, would that not be a regarded as violation? And my conclusion is that it possibly could be, just like we always say in the law.
And that's because the condition does not necessarily limit her major life activities, but it is perceived as a disability. And that's really what this regarded as provision of the ADA was meant to prevent. So with that, I always like to give our listeners a couple of takeaways. So I'll start with the first one. And the important thing for people to know is that a claim for discrimination brought by someone being regarded as disabled is just as viable as a claim for discrimination brought by someone who's actually disabled. It's the same rights. John, do you have a good takeaway for people?
Yeah, my takeaway relates to the topic of the rumors you mentioned earlier. If you're an employer and there are rumors that employee X or employee Y has any kind of medical affliction, shut it down. You have the responsibility to keep your eyes open and keep your head out of the sand and shut down rumors.
I like it. And I guess my final takeaway would be employers need to train their supervisors because those offhanded remarks and things like that can lead to potential lawsuits. And this is an area that most supervisors don't even know exists. Education for supervisors would be that ounce of prevention that's worth many, many, many pounds of cure to avoid a claim such as this. So with that, I want to thank you, John, for joining me in this discussion of the regarded as disabled provision of the ADA. And I want to thank our listeners for joining us here on the Employment Law Counselor podcast, where we try to make sense of the world of labor and employment law. On behalf of myself and John Baker, we thank you for listening. If you enjoyed this episode, please leave us a 5-star review, tell your friends, and subscribe to the podcast. For more information on this and many other topics, please visit our blog at www.theemploymentcounselor.com. Until next time, stay safe and stay compliant.